Don had come home and told me that he'd been experiencing chest pains at work, told me he had an appointment with his doctor and he'd be, telling her about that. And what he gets is a referral for a treadmill test, which doesn't occur for 9 days. And then on that treadmill test, again, he experiences chest pains, difficulty breathing. They discontinue the test. And again, they do not send him to ER. He does not even see a cardiologist that day. And he passed away 5 days later.
There was a system-wide failure where cardiac patients don't necessarily have the right to get to see a cardiologist. They first have to go through a cardiac nurse who runs the treadmill stress test. If your cardiac nurse is not as bright or insightful as some others, he or she might miss a sign or a symptom that, in retrospect, here was significant. Jeff Clary, a lovely guy, underwent a decompressive lumbar laminectomy at L3-4. Of the 7,000 of these surgeries that the continuum of experts in that case had done, they had experienced this outcome 0 times.
When I woke up from the surgery, immediately I knew that there was something wrong. I couldn't urinate. They were telling me that it was most likely just, part of the after effects of the surgery. But after a few days, I knew that it was more than that.
We believe that during the laminectomy portion, with the use of a cutting burr, either the surgeon or the assistant surgeon allowed that cutting burr to penetrate the dura and to severely injure sacral nerve roots 2 through 4, which control bowel and bladder function.
A friend of mine referred me to another neurosurgeon, and he thought that there was grounds for a lawsuit. So I contacted Dan and set up an appointment and knew right away that he was the right guy.
As plaintiffs, it's our burden to show by a more likely than not standard that there was a failure to comply with accepted standards of care, and that failure was a substantial factor in leading to the end outcome. As a plaintiff lawyer doing medical malpractice work, we need to know enough medicine to effectively cross-examine the defense liability expert and the defense causation expert against the backdrop of a $250,000 non-economic damages cap. In a situation like Jeff Clary, for example, he suffered a really bad injury, but there really was not a huge economic component to it. So that just underscores the inherent unfairness in putting a cap on non-economic damages. Susie Kirsten, same thing. I mean, the loss of the life of her husband of 30 years, $250,000, $1975. Really?
How do you put an amount on a loss like that? There's not enough money in the world to ever make that right.
The insurance companies clearly, can and will and do outspend us on every case. The costs that we have to expend to prove our case, our liability case, our causation case, our damages case, those costs are steadily rising through the years. The damages cap is not steadily rising through the years, so that means that our profit margin, that which enables us to stay in business, is slowly shrinking through the years. The reality is it's an unlevel playing field.